Welcome, everyone. We're going to continue on with our podcast today, but I have the benefit of Susanna joining us.
Hello, everyone.
We had a good week last week, Susanna, talking about duties. So we're going to dutifully continue to talk about duties. And the reason why it still comes back to is this isn't about going back to law school, but it is about keeping focused on what are primary obligations and duties, because that tends to lend us to A, understand what our practical duties are as executors and trustees, and B, gives us an opportunity to sort of, in plain English, explain some of these concepts to the clients who kind of wonder why they have to do some of the things they have to do. So we're going to talk about some of the things they have to do being difficult to manage with the client's expectations. Why don't we start with just launching into the topic of duties, Susanna, in connection with distributions and special problems relating to distributions.
Sure, Ian. I think one of the easiest illustrations is when we're dealing with minors. And we know that, when a will leaves a bequest to a minor, if that provision isn't specifically leaving the money to a parent or a guardian of a minor, then there's going to be some kind of an obligation to hold that money in trust until the minor becomes of age. And so the language we always see is, of course, you can hold and invest it, and you can attribute income and capital for the benefit of the minor during, the period of the time that it's being held in trust. If there isn't that kind of language, of course, in the will, then it's going to have to be paid into court. And so a trustee is going to deliver an affidavit to the Office of the Children's Lawyer, going to deliver an affidavit to the accountant of the Ontario court, and arrange to make that payment to that minor into court. And once that's done, of course, then the trustee will have the benefit of a discharge, just like they would have, it was otherwise given to someone who's authorized to accept it on behalf of the minor.
Okay, Susanna, so carrying on with these unique assets, the rule in Saunders and Voce, which we all sort of have in the back of our mind from time to time coming up in the area of estates and trusts, it's a pretty straightforward rule. Essentially, if there's no gift over, the beneficiary can call on the gift if it's sort of an attempt to set it up in a trust arrangement. But it's also a positive obligation on the executors to identify to the beneficiaries if they think the executor thinks the rule applies.
Yeah, I've always found that one a little bit interesting, because we've got our obligations, of course, and we think as fiduciaries to the testator to do what they intended or wanted to be done by their will. And yet there's this obligation that, if a beneficiary is able to collapse a trust, we're supposed to tell them that. So I think it's a great thing to sort of keep in mind, because it's not necessarily intuitive.
And of course, the Variation of Trust Act comes into the play here, because you're not bringing an application under the Variation of Trust Act. You're actually distributing in accordance with the terms of the will that are insufficient to hold the money in trust.
Yeah, absolutely.
Another failure that is sometimes not thought of, and certainly can be in the right circumstances, a breach of duty, is the failure to convey in specie devises. And that in and of itself sort of surprises some of our clients. But the question, of course, arises in those situations where you have an obligation to deliver in specie and you fail that obligation.
Yeah, and I've also seen it on the flip side, Ian, where a beneficiary may ask for something to be distributed in specie, but it's not specifically gifted to them. And then the question is, well, can the trustee do that? And if so, what is the best practice? And I always tell my clients that if we can get everyone's consent to its value and to, the actual transfer in specie, that's the safest means by which to proceed with that kind of a bequest.
Susanna, there's also sometimes we run into situations where a charitable bequest to a charity that no longer exists. What do we have to do in that situation as a trustee, and what do we have to be mindful of?
I think that just really highlights the this whole cypre doctrine that has developed through the cases, where the idea really is that we want to uphold the testamentary intention. And so if the trustee has created a charitable trust, the idea is that they've chosen some specific purpose to that trust or intended beneficiary of that trust. And when that individual or that purpose can no longer be fulfilled, then we've got the benefit of this doctrine where we might be able to, effect the gift as close as possible to what was ultimately intended. And so that's where that whole doctrine has come into play, so that we can protect and prevent these kinds of trusts from otherwise failing.
And an easy illustration is if you're giving to a charity and you use the word, for example, cancer in it, but the charity either is misdescribed, which won't happen with the estate planner because you just need to go into our automatically linked list to the CRA list of charities. But sometimes a client will have you, or historically something has been used, a charity that's misdescribed. And you work with the Public Guardian Trustees Office and you come up with a solution typically. So for example, cancer, you would go look for the Canadian Cancer Society, and then you'd have to look at the national and then the local and talk to them all and figure out a way to come up with a cypre, or basically a close enough solution.
Yeah, and it's always a lot easier if we can get the consent of all the beneficiaries, but if not, then, procedurally, we're going to have to bring an application before the court for advice and direction so that we can get the comfort of a court order saying, yes, you can pay that money out to that particular institution, so that, again, we're protecting against liability.
So Susanna and I and others are going to, with Kim Whaley's office, actually are going to be doing a full seminar on some issues relating to digital assets. And we thought we would just like to, and that'll be in June through the Canadian Lawyer connection there. But we're going to have one of the authors of a new book, a second edition of the book called The Digital Estate, actually on the seminar with us, Lee Sager. But it's a book that's just come out, the second edition has just come out. But what they've done is they've talked about some sort of unique duties that exist for executors. And, we come back to sort of 101 on fiduciary duties. And the definition of a fiduciary duty includes, of course, the duty to act in good faith, not to make a profit out of the trust, and not to place yourself in a position where your interests may conflict, or not to place in a position where you may benefit from your role beyond, of course, compensation. So what I wanted to just speak to briefly was that as I say, the authors of this textbook have spent about 400 pages on this, so we won't get into it too deep today. But this whole question of digital assets and how it ties to fiduciary duties that exist for us. Susanna, did you have any initial thoughts on that?
I think, you've just sort of highlighted what the obligations are when we're talking about fiduciary duties. And when we're dealing with digital assets, we've got different kinds of them. But the easiest one for me to get my head around anyways is when we're talking about computers or computing devices, cell phones, that kind of thing. The whole idea when we're dealing with those kinds of assets is really this need to secure them and to make sure that we're, protecting them to the extent that we possibly can. And that's because, as someone who owes a duty of loyalty to the state and the state beneficiaries and, ultimately the testator, we want to make sure that if these assets are in our control or our possession, or if we, entrusted to take care of them, that we are keeping them secure. And the risk, of course, is that if we don't keep them secure and there's either personal or some kind of sensitive or confidential information that is on these devices and it's not ultimately protected, then of course we're just opening ourselves up as fiduciaries to exposure and to being criticized for not having done so properly.
So as the authors in this textbook talk about some of the practical steps that the duty includes with regard to securing digital assets. And I'm just going to go through a few of them because, it's not just that we've got to worry about security. What does that involve? Well, first of all, they suggest that the software needs to be always kept up to date to help preserve and secure the data that you're working with as an executor. The entire, they suggested the entire hard drive or storage area of the computer or whatever tool you're working with should be encrypted. And encryption is one of those things that we as lawyers are still dodging a bullet on, I think today. We still send emails on a non-encrypted basis, and it always amazes me, but that's a debate for another day. But they suggest at the point of death, that encryption should be also something to consider. What cloud services you're using. I know we were very careful when we created the estate planner, was that we wanted to make sure that the cloud service we were using was a Canadian-based cloud service, so that we wouldn't run into issues relating to cross-border matters.
And even then,
yeah.
encryption becomes important, because even before you send it up to the cloud, you want to make sure that it's protected so that it doesn't somehow become compromised on its way up to the cloud, in a sense.
Well, that's right. And really a fiduciary, I mean, we all have this obligation we put on our emails, don't click a strange link and all that to download the nasty stuff that gets downloaded improperly. But as a fiduciary, you have the even higher obligation to make sure that you're not clicking on unprotected links. And the authors talk about that. And they also talk about the expectation that executors, once you're taking over the digital data, should be thinking about and organizing software for protecting antivirus software. And then finally, they talk about, before we get to passwords, they talk about the idea that the devices themselves should be protected by a firewall. So I've just given you some illustrations, as to the extent of the fiduciary duty that an executor has to preserve security. And it's an extent that I would say is not often considered today, or B, done. Mm-hmm. And so I'm very mindful of the fact that the courts continue to push the limits of fiduciary duties on us. So I'm now more and more saying to my clients, the old adage was, make sure you control all the assets. Go into the house, take your iPhone around, get all the contents videoed, change the locks. Well, I'm now going through a step-by-step. I say, what computer devices do we have, and what are we doing about them? It's not just making sure at the minimum. These are some of the things that I've particularized that the authors say, there's going to be case law that fiduciaries are going to get considerably dinged for if they're not taking even minimal steps, such as creating these early steps. I don't know.
And you can see, certainly, it's going to really depend on a case-by-case basis, right? Like if we were talking about securing my dad's computer as opposed to perhaps securing my computer, you can imagine how perhaps the duties are going to be a little bit different. But certainly just going through that mental check and saying, okay, should we consider this? Should we do something more than just the bare minimum? I think is going to probably become our standard of expectation eventually.
Well, I think it's really has to start to be top of mind with clients to consider this as important as changing your locks. It's just, as you say, to what extent? Mm-hmm. And sometimes you get in a state administration where you're not changing the locks. You're just saying, well, you know what, we don't need to change the locks in this situation. Those who would have a key, you're all safe. But it's, as you say, it's all fact driven. But there, if we're dealing with an arm's length administration, these are things that need to be considered. The authors go on to talk about passwords and the importance of passwords. I don't know if you had any initial comments on that before I go into the details of some of the suggestions they gave.
Yeah, always important. I know certainly even on the estate planning side, collecting a list of passwords, very, very important. And, once you're stepping into the role of taking care of and having control over someone else's digital assets, the passwords become particularly important because we want to make sure that we're protecting things as much as possible. So we're trying to avoid, for instance, short or memorable passwords, but creating long ones. Always when you're in these situations or complicated ones, there's a trade-off between convenience and security. And as a fiduciary, we're going to want to aim more towards the end of security as opposed to convenience. So having different passwords for different things, and ones with lots of different characters and things that aren't easy to break or to guess become particularly important. And of course, if there comes a time when we are concerned about the security of a particular password, making sure that we're changing it as soon as that kind of concern arises, I think is something that we want to keep in mind as we go forward.
Absolutely. So two other practical points that the authors make in their textbook is, one is they still go as far to identify the following. They say each password should have 12 or more characters. should include upper and lower case letters and digits if available in punctuation. So it's the sort of minimal expectation that we would often find when we go into it, set up an account on something online. We sort of intuitively go to that, but it was interesting. They came right down with what is almost setting the standard of care at that point. And the last thing they talk about is just be very careful about the use of Wi-Fi, and that too is private and that it's encrypted and protected. So in the last part of the podcast today, we want to talk about, come back to some, so to speak, come back to earth a little bit. We're going to dive deep, as I say, in June on the digital assets issues. But for today, let's carry on with our list, and in particular, the list relating to investments. And of course, our fiduciary duties there, the investment portfolios, and so on. So the first observation I always make to my clients is that, of course, the banks always say they won't let you get touch the investments until you get probate. And I always say, be very careful about that. Push back on that, because if you want to play the market, and I always have this in writing, I say, if you're going to play the market and keep the investments as they are, or watch the investment portfolio managed on a discretionary basis during your administration, God bless you. But no one's going to thank you for going up, and they're going to sue you for going down. Even without probate, although I've had these fights many times and not won them as fast as I'd like to, is the option to go to the banks and say, we're not asking you to distribute, we're asking you to put it into cash and to put it into an investment portfolio that's completely secure while we're in the course of administering the estate. And as I say, it's not always met well with by the banks, but a stronger, clearer letter about the consequences of them leaving it in the market during this period of time typically gets their head turned around. But that's just a practice point I have with regard to because the exercise of that duty is so easy to criticize. Mm-hmm. But Susanna, why don't we just take a moment and just an overview of the Trustee Act and some of the expectations that have been crystallized since 1999 when the act was changed.
Yeah, back before 1999, we knew we had a list of authorized investments that trustees were entitled to look to when they were dealing with, investing in state funds or trust funds. And with the change in 1999, we moved towards a prudent investor standard of care, where this list of authorized investments was replaced with some kind of expectation that the reasonable person or a prudent person would have the discretion to invest in certain things as long as they were ultimately something that would meet the minimum standard of care. And of course, part and parcel of that would be this need to consider diversification as well. So we don't want to be putting all of our investments in one particular vehicle, but we want to make sure that we're putting them into ones that a reasonable person would consider with their own assets investing in, and trying to meet that minimum threshold.
Right. So we have that. And as I say, no good deed goes unpunished if you play the market. But God bless you if you want to. And I literally had an estate the other day, and I said exactly the same speech. And they said, no, we're going to play the market. So I said, no problem. I'm going to write you and tell you that I don't know how great an idea it is, but it was your choice. All right. Susanna, let's move down our list, because we want to try to get through this as much as we can this week. Before we're back with Jordy next week. The question of duties to third parties, that's one that isn't natural to clients, and certainly to executors, lay executors who don't understand some of those obligations. So can we just sort of set the stage with that point, and then we can talk about some particulars? Yeah,
I think the easiest way to think about that is to consider creditors. If someone has an estate that has incurred liabilities while the testator was alive, then of course those are things that are going to have to be paid before the estate can ultimately get distributed. So whereas perhaps the beneficiaries are looking to the trustees to protect their interests, so are these third parties who are legitimate creditors of the estate and are ultimately entitled to be paid for. And
of course, we've got to be mindful of the Bankruptcy Act, which of course would prevail in a situation where you have an insolvent estate. And of course, gives us some protections on things like costs and executives' compensation being paid off the top with the funeral expenses. But the Bankruptcy Act rules, of course, are important to have canvassed with your client if you're in a situation where it's an obviously insolvent estate. And as I say, as it comes back to our duty to third parties gets expanded to creditors very quickly.
Yeah, and I'm actually surprised of not how many, but I've seen more than I would have expected recently insolvent estates where I've been consulted by trustees who are saying, well, what do we do here? And one of the first things I always try to remember to warn people about is the fact that they don't have to take on that role. If they are legitimately concerned that there will not be an estate to administer and that there somehow could possibly be exposed to some kind of personal liability, it may be better just to not even touch that at all once you become aware of that possibility.
Well, that's right. And it always comes back to no good deed goes unpunished again, as the saying goes, because of not considering that at the outset. All right, so just winding up our thoughts today, we want to just cover off some of the duties of guardians and attorneys. And of course, those duties are established by the common law, but we've been in Ontario been given the benefit of pretty comprehensive legislation that also outlines the duties, and we want to just highlight a few of those today, and in particular where some overlap with estates and trusts. And of course, that legislation, the SDA, has not been touched much since 94, but 92 when it first came out. But it certainly gives us some good guideposts on the basics. So, for example, our obligation to consider certain aspects of a management plan and the expectations of the attorney or guardian who's applying or who has been given the job.
Mm-hmm. And really, the guardianship plan and the management plan become the roadmap for the actual guardians, the power of attorney document for an attorney to some extent. And then, as you say, and it's all supplemented by what the SDA says in terms of other fiduciary and other, accounting obligations.
And we have Section 7.2 of the Substitute Decisions Act, of course, gives you the general powers of an attorney appointed pursuant to a power of attorney for property, for example. And Section 31 provides the same powers for guardians of properties as well as personal care. So one of the classics is prohibition against making a will. And that seems to be the threshold point of conduct when you're observing what your role is as a guardian or as an attorney. How far can you go? And the threshold seems to be, in accordance with the provisions of the Succession Law Reform Act, you're not entitled to do what would be perceived to be a testamentary act.
And so that takes it outside of the four corners of just a will and opens up the question as to, as part of an estate plan, can you designate beneficiaries as an attorney or a guardian? Can you change RIFs to LIFs, at a certain point in time? Can you create alter ego trusts? So it opens up a lot of these questions and whether or not those kinds of acts are testamentary and whether they are caught by this prohibition or not.
So one of the nice things about the Substitute Decisions Act, anyway, is that it talks about liability and the extent of the standard of care, but liability for breach of a fiduciary duty. And it breaks it down into the economics, right? It comes down to if you're being paid compensation or you're not being paid compensation, what microscope are you going to be under? Mm-hmm. And I find it a fascinating delineation that many of us, when we're in a contentious situation where someone's throwing mud at the wall, you take a lot of heat off your client when maybe they weren't perfect about accounting, or maybe they weren't perfect about some of the fiduciary duties they were expected to follow. And then you just take the heat off and say, well, look, they're not taking compensation. They were doing this for their mother. Maybe they didn't keep the greatest records. Now our standard at trial is going to be lower, mm-hmm. and it's driven by the economic decision.
It's a good point. And one of the things that I always found interesting when I started practicing is that, most people know when they're appointed an executor under a will to go and see a lawyer and get some advice about how to be an executor. when I started, I never saw anyone going to a lawyer and say, hey, I'm an attorney. What do I do with this? Certainly with a guardian, it's a different situation, but an actual attorney going and seeking some advice in terms of the expectations and what kinds of obligations they have. So, it doesn't come as too much of a surprise that someone's taking compensation is going to elevate the expectations of what they're, but it is certainly something that becomes a point of negotiation when we're into a very litigated environment where people are criticizing with the benefit of hindsight, just someone doing good for goodness sakes otherwise.
All right, Jordy, as we're winding up, I don't know if you're actually online. I know you're mediating today, and I don't know if you had anything you wanted to add before we conclude. Look at how dressed up he is. Ooh, this is a big day. You're going to see the Queen. Well, no, now the King.
Right. Yes, I got dressed up for Susanna, not for you, I can assure you. No, I was just listening with interest about fiduciary duties and the guardianships and the issue about digital assets, which is one we can easily overlook as far as in the context of fiduciary duties. It's a very complicated area that nobody really, I don't think anybody has come up with a great solution. So I look forward to the seminar that you're having with Kim later in the year. So
thanks a lot, Jordy. All right,
Thank
well,
you.
we're just about out of time. And did you have anything to talk about for next week or from an estate planner standpoint?
Well, we're going to see you next Thursday. We're just trying to organize the different topics that we might be doing because I'm trying to get a guest speaker about U.S. law and what we have to worry about when we've got Canadian beneficiary or Canadian testators with U.S. beneficiaries. Kevin Gluck is going to be coming. We don't know if that's going to be next week or later in the month. So keep your fingers crossed. We'll let you know, and we'll hopefully see everyone as well, or our estate users on Tuesday when we're going to talk about personal effects and pet gifts and how to do those in estate. And thanks.
Great. Thanks everyone for joining us. We'll see you soon.
Thank you, everyone. Thanks, Jordy.
Take care.